The non-compete ban has just been struck down nationwide. And don't worry, I'm in a car, I'm not driving, I'm a passenger. But in the US, the non-compete ban that's supposed to take effect September 4th was just struck down by a court in Texas. The case is Ryan LLC versus the FTC. And for a lot of us, we aren't that surprised because at the beginning of July, this same judge issued a limited decision halting the non-compete ban from taking effect for a small group of employers and was taking her time to look at it overall. Well, that decision just came out. So the non-compete ban under that decision will not happen on September 4th. So what does that mean? So people who were like, non-competes are going to be illegal, that's on hold. And employers who were supposed to send out notices to employees saying you don't have a non-compete anymore on September 4th, that's on hold as well. So now this plays out in court. So there are two other decisions I've talked about. In Florida, there was a lawsuit by the villages. There, the judge issued another narrow decision, halting the non-compete ban for taking effect from the villages, but also in Pennsylvania. And there, the judge in the case brought by ATS Tree Services, a small tree company, had said that the ban could still go forward. So you do have a circuit split, but this judge's decision in Texas will halt the ban from taking effect. And so now both the FTC can appeal in court to the courts of appeal. That's the next level, and the level above that is the Supreme Court in federal court. So those appeals can happen, but I think it's unlikely, personally, that any change would happen, and so I don't expect the non-compete ban to be reversed and upheld by the Court of Appeals and take effect on September 4th. So while this plays out in court, if ultimately it does get to the Supreme Court, most legal experts expect that the Supreme Court would decide just like this Georgia judge in Texas did and say that the non-compete ban can't go forward. And why is that? People have asked about Chevron deference. That's because that's something that was overturned by the Supreme Court in a case called Loper-Bright. Well, yes, the Supreme Court, most people would expect, would say very similar to what this judge in Texas said, which is that the FTC as a federal agency doesn't have the legal right to issue such a sweeping ban on non-competes, that this would have to be done by Congress. So while this gets appealed in court, then the ban will not take effect nationwide, but also politics can affect this. So with the election coming up, presidential election in the US, then if Vice President Harris wins, then most people expect that her FTC would continue to push for this ban and is appeal to the Supreme Court. But again, people expect the Supreme Court would likely strike this down as well. And then if President Trump were reelected, then people expect that his FTC could say, we don't want to appeal this as much, that we're not focused on making this non-compete ban happen. So a lot of the avenues, again, people that are legal experts, not just me, have said that they never expect this ban to take effect. And it can be really disappointing to all of those employees that had looked and said non-competes aren't going to be a thing as of September 4th. And a lot of people did expect this based on courts and political climate and decisions by the Supreme Court. So those employees that were looking forward to September 4th, that's on hold. And also those employers that were going to send out that note on September 4th to employees that you don't have a non-compete. All of that's been on hold by the judge in Ryan LLC.